Hi, everyone. Today, we are looking at the issue of children, and we have some speakers who are going to educate us on this issue. And so I want to introduce Madame Agnes Limante, who is an expert in her own right at the Lithuanian Center for Social Sciences, a researcher, and an acclaimed human rights advocate. Without much ado, I would now hand you over to Dr. Agne Limanti.
Good morning to everyone. My name is Agne Limanti, and I'm a chief researcher at the Law Institute of the Lithuanian Center for Social Sciences. My topic in today's session is legal aid for children in conflict with the law. To cover this issue, I will shortly talk about international standards for providing legal aid to children, present you a brief overview of practices in Europe, and will then discuss what is covered by the concept of child-friendly legal aid. A short note should be made here that I will focus on children in conflict with the law and will not go further into other areas such as civil cases or family law disputes. My presentation is based on the findings of the EU co-funded project, Legal Aid for Children in Criminal Proceedings, Developing and Sharing Best Practices, or LA Child project, as I will refer to it during my speech. This project is implemented by the consortium of partners from Lithuania, Belgium, and Albania. It started in February 2020 and will end in the end of this year. The project started with the evaluation of regulation and practices in European states when providing legal aid for children. For this purpose, we did a desk research in 14 European countries, and we also conducted semi-structural interviews in 3 of them. Besides the European Union, the Council of Europe and international regulation in the area was analyzed and summarized. At the moment, on the basis of the collected data, we are finalizing development of guidelines in providing legal aid for children in conflict with the law, which will be shared across Europe. If you would be interested to learn more about our project and to find its materials, you are welcome to visit our website where the information will be available. Let me now begin with the international regulation. I have to notice that children's rights have developed considerably in the last 3 decades. This also applies to the area of legal aid. In international law, children suspected or accused of crime have a well-established right to legal aid. It is commonly agreed that they should benefit from the same fair trial guarantees as any other person in conflict with the law. Nevertheless, the right of the child to legal aid continues to be developing. In particular, its content is changing. We agree that children have right to legal aid. We agree that it should be free in criminal cases. And now we go further, asking legal aid to be adjusted to the child needs and to be of certain quality, not only formal, but that which is tailor-made for child. Therefore, in more recent documents, the concepts of child-friendly approach, child-friendly justice, child-friendly or child-sensitive legal aid are being used more and more often, and this has further implications on the content of legal aid. As an example, I should mention the 2012 United Nations Principles and Guidelines on Access to Legal Aid in Criminal Justice System. This was the first international instrument dedicated entirely to legal aid. What is important, it gave a considerable attention also to children's right to legal aid. Importantly, the United Nations Principles and Guidelines define the concept of child-friendly legal aid. This definition highlights important elements of child-friendly legal aid, such as accessibility, understanding what the child to legal aid should be age appropriate, responsive to the needs of the child. It also repeats the importance of specialized training of legal aid lawyers, not only legal training, but also training that would enable lawyers to communicate with children effectively. Besides this United Nations document, several other instruments should be mentioned. I will just mention a couple of them. In 2018, the UNICEF developed guidelines on child-friendly legal aid. This document is designed to be a practical tool to support both experienced and newly qualified legal practitioners in their daily work protecting children's rights. Furthermore, in 2019, the General Comment number 24 on children's rights in the child justice system was adopted by the United Nations Committee on the Rights of the Child. This document also brings attention to the child's right to legal aid. In all those documents, it is underlined that legal aid to children should be provided from the very beginning of the child's contact with the justice system, that the legal aid should be child-oriented. Specialization on and training of lawyers who provide legal aid to children is also always underlined. Similar principles are also repeated on European level, for example, in Council of Europe documents or in the documents adopted by the European Union. How are these principles in fact reflected in national laws in Europe? When we did our analysis in the 14 European states, we have noted that most of them established the right to legal aid in their either constitutional documents or in the civil codes or criminal procedure codes. Often states also have separate law that is fully dedicated to legal aid. Legal aid for children in conflict with the law typically deserves a special attention in such national laws and criminal proceedings and related instruments. For example, very often, due to the vulnerability of children in conflict with the law, states establish mandatory defense for children and do not apply means test. An example of such countries could be Lithuania, Belgium, or Albania. In many European countries that we analyzed in our La Child project, however, legal aid for children is regulated by the same instruments as legal aid for adults. In those instruments, nevertheless, we will find provisions that specifically address particularities of legal aid to children. In Lithuania, as an example, there is no law or a policy document that would be specifically addressing legal aid to children. However, our Code of Criminal Procedure includes special provisions on legal aid to children, for example, providing for mandatory involvement of the law in the examination of cases, or limiting the child's right to waiver of the lawyer. A common principle that could be identified in Europe is that specific attention is paid to legal aid provision to children. This leads to the assumption that European states recognize that legal aid provided to children should be child-friendly. However, states should still better define the concept of child-friendly legal aid and set more clearly as its goal. As regards accessible legal aid, our research study revealed that in Europe, in criminal cases, legal aid for children is mostly free, and it is not subject to further means or merit tests. The mandatory representation of suspected and accused children, in fact, is a very good rule. It's a good practice that should be followed and implemented in other states, not only in the European Union. It is also important that legal aid that is available to children in criminal proceedings is provided very early, from the very beginning of the process, from the first interrogation by the police. Surprisingly, though all the states of Europe where we did the research provide for the right to legal aid to children in conflict with the law, the children themselves are not always aware of this right and especially of its scope. In this regard, it's important to develop tools that would enable children to have access to information on legal aid, especially once the child is deprived of liberty. Bills of rights, which are presented to children, usually do include a note on availability of legal aid. However, what we noted during the interviews with professionals, it was stressed that such provisions are often technical in nature and not always clear to children. it is quite hard for them to understand and to comprehend their rights. Therefore, leaflets or interactive tools in police stations could be of help in this regard. The interviews conducted in Lithuania, Belgium, and Albania revealed the importance that legal aid should be delivered by lawyers who are specialized in the child justice. It's important that such lawyers not only have the legal information, but also they have to understand the child justice specifics, and should also have the profound understanding of child psychology and development. In some countries, legal aid lawyers are specialized, and there is such a category of lawyers, youth lawyers as a legal aid lawyers. Belgium, Finland, Albania, Italy, and France were the examples we identified in this regard. Such youth lawyers is a very welcome practice, because such lawyers would then have more experience in dealing with children. They also usually have targeted training and work with the cases with children much more often than it is in the systems where no such category of lawyers exist. But at the moment, I have to say that most of the countries still do not have such specialized lawyers. However, most of you, I believe, would agree that all legal aid providers who are working with children should receive basic interdisciplinary training on the rights and the needs of children of different age group, as well as on proceedings that are adapted for children. This training should include psychological and other aspects of development of children. In countries where there are specialized youth lawyers, they are usually trained specifically. In countries where no such specialization exists, it should also be considered whether such kind of training should be included in the general programs. As regarding age-appropriate legal aid, it's a very linked question to the specialization of legal aid lawyers as well. The idea that legal aid should be provided to children should be developed, taking into account their needs, should be tailor-made, taking into account their age and the development level, is not new. It's repeating during the instruments, during the analysis of the instruments we analyzed, and also in the state practice. In our research, we noted that even though there are guidelines developed on international level, these are not always known to lawyers. And on the national level, in fact, there is little guidelines to lawyers on how legal aid to children should be different from that which is provided to adults. Consequently, child-friendly legal aid service standards or professional codes offering guidance on how to deal with a child in conflict with the law in a child-friendly approach would be greatly beneficial for all the professionals engaged in child-friendly justice cases. This also shows that there is still need to do a lot to have legal aid child-friendly. As I have limited time, I would like to conclude already here, and I would like to underline that every child facing justice as a suspect or accused person is entitled to accessible, appropriate, and quality legal aid. And the respect of his or her rights will strongly depend on the assistance he or she receives. This calls us to consider whether the national practices in our country is appropriate, or some other steps should be taken to advance the rights of the child in this regard. Thank you for their attention.
Thank you very much, Dr. Agni Limante. I want to say we could not have a better topic than at this time during COVID for children, especially when you're talking about children in contact with the law and in conflict with the law. And we're happy that some research has been done. Definitely we'll be contacting you to learn from what you people already have done, which will help our respective countries. Now I am going to turn it over to some questions. I would ask Jane first to maybe put her comments and questions to you. Thank you very much. Can you explain a little more about the components of a child-friendly system?
This question was for you, Agne. I want you on mute.
Agne,
Yes.
are you?
Yeah, I'm here. You
Yes,
probably
we're
can.
talking about a child-friendly system. Can you let us know more about it?
As I did in my speech, the child-friendly legal aid requires several elements to be present. So first of all is what we see in all the international documents, what we see in the state practices, is that this child legal aid, which is provided to children, it should be adjusted to the child needs. So the question arises, what does that mean in particular? In my opinion, first of all, we need to have the lawyers which are specifically trained to work with children. Not only the lawyers who have finished their law degree and have the basics of the legal training, but also which have a specialized training, specific knowledge, how to talk to the child, how to proceed with the case, and how to use the possibilities which are provided by the child justice system. Another element, I think, which is also very important, is that the child should have the possibility to have legal aid from the very beginning. And it should not be really a possibility, but should be a general rule, like a mandatory representation of the child. Once the child is in the police custody, it should have be granted the lawyer which will assist him, which will explain how the system works, what is his role, what is his possibilities, what is his situation. So this, from the very beginning, from the very first moment, the child should have a lawyer, and it should not be dependent in any case on his financial means, on his parents' financial means, and in no way there should be a possibility for the justice system to manipulate the child and say, for example, that you don't need the lawyer. There should be a general rule in the legal documents requiring the legal professionals to enable the child to communicate with the lawyer before any further procedural steps are taken. So these are
Thank you. You know, yes, I am very happy to hear about the study. And you discussed the issue of age assessment for children. I am in a third world country where half of our children do not have birth certificates. And part of the problem which we encounter with children on trial in contact and conflicts with the law is about age assessment. What can you advise me in terms of your study?
It is a very hard question, actually. What we did in our study, we work with European Union countries. In European Union, everybody has a birth certificate. It's very limited amount of people who might not have birth certificates. It's totally not common, right? So what you have in African countries is a very different world to what I see, to what I know. It's hard to say. Of course, from one side, you can say that the public officials could do their best to ascertain the age of the child. But of course, if the child is 17 or he's 21, it's often very hard to say. So this is the situation that should be dealt from the very core of it. Yeah. So to have human rights, you have to have the personal identity, first of all, personal birth certificate, passport. So you start with that. Until it's possible, the only suggestion I could have maybe to have presumption in the favor of the child. It's better to allow somebody to manipulate the system than to not give the rights to the children, which they should normally have.
Now, what constitutes fair trial rights for children in Europe, in your estimation?
So first of all, right of defense. Then for children in most of the countries, we have the special rules. They are not going to the general court procedure, there are child justice procedure. They have different, even the judges, they take different perspective on children. It's more not about punishing the child, but about educating him, about turning his way, turning his thinking, trying to help him to become what we call a law-abiding citizen. So help and assistance to the child is the first moment. Punishment is for the adults. Even for adults, we are talking about rehabilitation, resocialization, and other things. For children, it's the main thing. Another fair trial guarantee for the child, as I said, is a right to a lawyer, because the child is not an adult. His knowledge is less than that of the child. He is much more vulnerable when he faces the law. And this means that the right to a lawyer is very important for a child.
Claire, maybe we can move to the second speaker and pick up all the questions at the end.
Thank you very much. Yes, that was my last question. Yes.
Okay, fine.
Thank you.
Thank you very much, Dr. Limante. We have learned a lot from you, and hopefully we would be trying to access the study. Thank you very much.
Thank you.
Our next speaker this morning is Mr. John McDade. He's the Chief Executive of Legal Aid Board in Ireland. And he also is a distinguished human rights individual in Ireland. He has worked in legal practice in Australia as well as in Dublin. He holds a master's degree of science and in business practice. So, fellow attendees, I now present to you Mr. John McDade. Thank you very much.
Thank you, Claire, and thanks for the opportunity to present today. I was speaking to the theme of improving how the voice of the child is heard on account of the extensive interest we in the Irish Legal Aid Board have in the area of family law. Our civil legal aid system operates a mixed model of service delivery using employed solicitors based in law centres and also using the Judicare model. Furthermore, we provide the state-funded family mediation services, and we do that exclusively through the use of employed mediators. About 68% of those who seek our legal services do so in relation to a family problem. Thus, both the effectiveness and the efficiency of how that problem is resolved are matters of keen interest to us. As a country, over the last 30 years, we've been good, if not indeed very good, at enacting family law legislation. However, where we haven't been so good is setting up or developing systems to properly and meaningfully implement that legislation. We're a country with a written constitution. It's been in place since 1937. It's been formally amended by way of referendum on 38 occasions. In 2012, we amended it by inserting an article that requires that in a wide range of court cases concerning children, provision shall be made by law that the views of any child who's capable of forming his or her own views shall be ascertained and given due weight having regard to the age and maturity of the child. Focusing on the private law side, we subsequently passed legislation to give effect to those constitutional provisions. That legislation enables family courts to appoint experts to establish and convey the views of the child and also to assess the best interests of the child. We've since made regulations defining who an expert is for the purpose of ascertaining a child's views and giving a report. And those regulations set what fees the experts can charge. In terms of who can be an expert, the expert must be either a psychiatrist, a psychologist, a social care worker, a social worker, or a registered teacher. Well, in terms of the fee arrangements, we took the somewhat unusual approach of setting maximum fees that may be charged by an expert. And the main fee is €325, which is inarguably modest in the light of what the expert is asked to do. And that's a maximum that's set regardless of whether the parents of the child in question have privately funded representation, are being legally aided, or are lay litigants. And from engagements I had with the department prior to the introduction of the regulations, my understanding is that the Minister for Justice was keen to ensure that interventions in relation to the establishment of the views of the child should be light touch and should not stray into more detailed best interest inquiries. Neither the Constitution nor the legislation offers any particular guidance in relation to the circumstances when a child's views report should be obtained, when it may be appropriate for a judge to speak to a child, or if there are other means of establishing and conveying the child's views. Furthermore, the legislation doesn't put in place any form of regulation or oversight of child's views experts. So in terms of how in practice the voice of the child is being heard in private family disputes, there's no data collected on the extent to which judges meet children, although there's some evidence, albeit slightly dated, that this is a rare occurrence. So for the purpose of today, this presentation, I spoke with a couple of two judges with extensive family law experience, both largely based in Dublin, and one of them very kindly canvassed some views of her colleagues. And both of them largely conveyed the same message. Strong reluctance on the part of the judiciary generally to interviewing children, and most judges avoid it where possible. Both of them noted the absence of training for judges in this area and expressed concern about unwittingly causing potential damage to a child in a conflict-ridden family. They also noted concerns around the potential coaching of children and around the physical environment for speaking with a child. They noted that a previous court president had initiated some training, but it had not been sustained. One of them noted that if there's a simple, straightforward issue involving a 17-year-old, they might interview the child, but that circumstance would be rare. The other noted a particular experience in the past where she felt that her interviewing a child in the presence of the parents led to an inappropriate disclosure being made by one parent, and she now never engages with children in the presence of parents. I asked both of the judges what their experience was of getting child's views experts. So somewhat to my surprise, both noted that while the situation was far from optimal, experts could be found to speak with children and convey to the court the views of the child. And this is in spite of concerns being strongly voiced that the maximum fees set would act as a deterrent to persons with suitable qualifications and experience putting themselves forward. Indeed, they noted that in Dublin, our largest city, there was a small number of experts who had established a business model that was sustainable, and the experience had been that these experts carry out the work professionally. The same judge noted that in the absence of formal oversight and proper regulation of the experts, judges were very dependent on the bona fides of the legal professions in order to make the systems work. And both judges noted that I had mentioned that a teacher was defined as an expert, but both judges noted that they had never seen a teacher put forward as an expert in practice. They noted that reports in relation to the welfare of a child could be more challenging to obtain on account of the costs involved. They observed that our legal aid rates for welfare reports meant that it was often not practical to seek such an intervention. And they did comment on some element of misuse of provisions in the public law childcare legislation to try and give them an opportunity to get a better understanding of the family dynamic and issues in relation to the children. One challenge we have at the moment is that there's no separate court division for family law, and arguably family law has been the poor relation within the court system. While an element of speciality has arisen in some of the larger urban areas, it remains the case that family law matters are often heard by a local or regional judge who will also be responsible for all other court work. There's no specific requirements of judges training or expertise-wise as a prerequisite to hearing family law cases or to engaging with children, although thankfully the government is now moving to address this and published last year a general scheme of a family court bill, which will require judges to be assigned to the area of family law for a minimum of 3 years. The bill also has provisions obliging judges to take such course or courses of training or education, or indeed both, as may be required by the Judicial Studies Committee. Another positive development has been the inquiry by a parliamentary committee into the family law system, and that committee reported about 18 months ago and made a series of useful recommendations, which I think will give some political support to the move for reform. So where to now? I want to mention two other specific developments. The first is the establishment by our Department of Justice of a family justice oversight group, and it established this group about 9 months ago. Just going back, two key recommendations in the Family Justice Review that was carried out in England and Wales a number of years ago were the need to address, firstly, organisational structures being complicated and overlapping with no clear sense of leadership or accountability and no one looking at the performance of the system as a whole. And secondly, the absence of a set of shared objectives to bind agencies and professionals to a common goal and to support joint working and planning between them. And I know that similar issues have been identified in other family law reviews, including a review in 2017 in just up the road from us in Northern Ireland. It wasn't difficult for me or for us to see that these issues were impacting now negatively on our family justice system, including on how the voice of the child is heard. There was no obvious leadership body, no vision statement, and no strategy on how to improve the system. In fairness to our Department of Justice, it has led the Family Justice Oversight Group proactively in its first 9 months. At the moment, the group is constituted of state actors only, including judges, a decision that has not been met with universal approval, though one strength of this approach is the relative absence of vested interests and the capacity to look at issues with a certain professional detachment, although the counter-argument might be that not enough of the group members are sufficiently proximate to events on the ground to be able to make informed decisions in terms of charting a future direction for the system. The group, in addition to receiving presentations from persons with particular insights into the system, has engaged or is engaging in a 3-phase consultation process. Firstly, with stakeholders, secondly, with members of the public who have participated in proceedings, and there was a public consultation that's just the closing date for submissions just passed recently. And the third and perhaps most interesting phase will take place shortly, and that's direct engagement with children who have been involved in are the subject of the family justice system. I'd like to be able to say more about this aspect, and in particular in relation to how this engagement will work, but this conference comes just a bit too soon for this. I see that I'm getting a time reminder. I'll try and move swiftly on. Widely acknowledged that and has been publicly stated by senior officials in the Department of Justice that improving the family justice system must lead to a greater centralisation and regionalisation of the dispute resolution architecture. It's not possible to have an optimum dispute resolution venue in every country, in every court area. What I do see happening is we'll have a limited number of venues as dispute resolution centres based on accessibility. Leads me to the second and perhaps final point that I want to mention. We in the Legal Aid Board have worked with the Court Service to lead a project, a 2-year project aimed at developing what an optimum family dispute resolution centre could look like. We've chosen one particular location. It's an urban and rural location. We've conducted to date 5 meetings with stakeholders. The most recent meeting was last Wednesday. The theme around that meeting was the voice of the child. Again, the conference may be coming just a little too soon in terms of charting a future direction, but some really strong messages coming through. First one, stakeholder mapping is a really valuable exercise, determining who the key players are and the extent to which they can influence the outcome of a project, really important. Second one, those experiencing family problems get their information from a range of sources. Some of those sources are much better than others. And third, and perhaps the most interesting one, easy to assume that individual stakeholders are aware of how the system works and what other stakeholders do. That's an assumption that needs to be challenged. One of the almost eye-opening aspects of the consultation process is the extent to which stakeholders don't know what other stakeholders do and how other stakeholders can support a person experiencing a family problem. And without being critical of lawyers, and I was one once, I thought this was particularly apparent among the lawyer participants in the consultation, who at times seemed to be very much focused on a process and how the process can be used for their client, rather than on a problem and how the problem is best solved for the benefit of all who are impacted by it. I did show a draft of what I'm saying today to the judges I spoke with, and one of them came back to me very specifically to endorse this recommendation. So look, I'm aware I've drifted from my theme. I have a little bit more to go, but I have the time reminder, so maybe I'll wrap it up there. Thanks, Claire.
Thank you very much, John. We are very happy to hear from you and learn about children in Dublin and what happens in the courts. Already we have one hand up. Manabu Waksuma, can you please come in with your question?
I'm wondering, do you have some kind of the statistics of your presentation? Can you hear me?
Yeah, no, I can hear you. No, I've certainly shared a written copy of what I've said. I've sent it in to the organizers, so I presume it will be available. In terms of statistics, we don't actually have probably a lot of statistics around this issue, and that probably comes back to one of the points that I was making around leadership and focus, our strategic vision and strategic direction, and we're perhaps certainly starting from a low base in terms of data and what's going on, and that is very much part of the oversight group's plans in terms of just getting much better data and trying to harden the information upon which decisions are based.
Okay, thank you very much.
Yes. I see another hand up.
Jane, I'm going to have another go. Can you hear me?
Yep, loud and clear.
Right. Thanks, John. I know that you said we're a little bit ahead of the direct engagement with children in terms of the consultations.
Yeah.
But I'm just wondering if you can make any comment on any of the themes that are emerging from the public and stakeholder consultations.
It's difficult to say, Jane, because literally I haven't actually seen the feedback from the public consultation. It closed the Friday before last and it went directly to the department, and they simply haven't come back to, I am part of the oversight group, but it hasn't come back to the oversight group yet in terms of what it's saying. The stakeholder consultations have been very extensive, and look, they're all, I think they're all, it's all very useful stuff. If I was to make one particular observation, and this perhaps comes from a stakeholder meeting we had last Wednesday in terms of the Model Dispute Resolution Centre that I'm very actively, I'm a project sponsor of it. And I think this probably reflects a lot of the other feedback as well, that everybody sort of says it's really important that the voice of the child is heard. And a lot of them are saying, look, you know, it's really good, and children are engaging with this agency and that agency and the other agency, and they're getting services from ABC. But the gap that I don't think is being crossed easily is how that's brought into a court process, and I'm not always sure even that a lot of the stakeholders are quite seeing that issue. In other words, they're recognizing the importance of how the voice of the child is heard, but they're not making that bridge in terms of saying, well, okay, so how do we get the, if a child is in, has a therapeutic intervention or is being supported by an NGO, we have NGOs specifically aimed at supporting children who are experiencing family separation, but those bodies don't want to come into court and offer views, very understandably. So the gap that we have yet to cross, I think, and I think this is going to become very apparent as the consultation process goes on, is how to bring that experience into the court environment or the judicial environment, at the same time always trying to minimize and trying to reduce the level of court involvement, and trying to improve the systems for keeping people out of a court to a much greater extent than maybe is the case at the moment.
Thank you very much. I see Andrea wants to ask a question. Andrea, please.
Yes, thank you very much. I'm a lawyer with Legal Aid Alberta in Canada. So I just query, is there a particular reason in Ireland why they don't have lawyers appointed for children to bring that voice of the child before the court? Because I look at who are the group, the psychologists, the social workers, the psychiatrists. Yeah. Just wonder why no lawyers.
Yeah, I suppose that's a very good question, and I'm not sure that's been fully rationalized. I suppose I don't believe the department felt that lawyers had the right skill set or expertise to maybe take the views of the child and to properly had the training for, to have the right listening skills, to ask or be able to engage with children in a way that asks the right questions, and then to be able to, I suppose, listen for the more subtle messages and be able to convey those to a court. We on the private law side, certainly we really don't involve lawyers in the family courts as representatives of children. I think we did pass legislation to allow it to happen about 20-something years ago, and we never commenced those particular provisions. On the public law side, we tend to appoint guardians ad litem much more often than appointing lawyers, and we do say they're largely to act for children, and we do say they're mutually exclusive processes. So if you appoint a lawyer, a guardian ad litem to a child, you can't appoint a lawyer to act for the child. The practice that has developed is that guardians ad litem are appointed, and then lawyers are appointed to act for the guardian ad litem. So that's how the system has evolved, but I think your question's a very good one and may well feed into the consultation processes that I've described, and that as I say, are probably in their early stages at the moment.
Thank you.
Thanks.
Thank you very much. We are very sure that John has really given us what happens in Dublin, and we've been able to ask as many questions as we can. Thank you very much, John. We would now go. Yeah, we would now go to our next speaker, who also happens to be another John. We have the Johns this morning, by the way. John Boisig, a renowned professor and lecturer, lawyer, and who is now the Chief Executive Officer of Legal Aid Act, and who has worked in various senior appointments in Australia, and who we are happy to have to also educate us on this issue of children. Without further ado, I present you Dr. John Boisig. Thank you very much.
Hello, my name is John Boisig. I'm the CEO of Legal Aid ACT here in Canberra, Australia. I'm here to talk to you about a new initiative involving young people and the law and education. As you know, young people represent some of the most vulnerable individuals within the community and experience a range of complex issues, often without sufficient knowledge to access the justice system. Barriers to justice are compounded for young people as they have limited autonomy and rely heavily on their parents or other adults, or more problematically, their peers and siblings. The complexity of the justice system is alienating for many young people, subsequently unaware of their rights and the manner in which they may be enforced. Even where they have sufficient knowledge of the justice system, it may continue to intimidate to the extent that young people refrain from making complaints or seeking redress for fear of repercussions. The concept of access to justice for young people is intrinsically linked to the empowerment of these individuals. This is why they must have access to information about their rights and the appropriate methods for protecting those rights. Whilst improving knowledge amongst young people is of primary importance, information should also be available to parents, teachers, and others working with and for children. As such, the availability of legal assistance services, increased awareness of their rights, and the role of the justice system in protecting those rights should be used to empower young people to overcome these barriers. I have been struggling with how to achieve this goal throughout my whole work career and employed various strategies with mixed success. It is in this context that the college's Legal Liaison Initiative was formulated. Well, what kind of service is being provided? The service run by Legal Aid ACT in Canberra is a justice education partnership operating in the 9 government-funded public colleges across the Australian Capital Territory. These colleges provide education for students in the last 3 years of high schools and are physically separate from students in earlier years of study. By embedding lawyers in the familiar environment of a college, we have sought to increase the likelihood that students, parents, and other relevant adults, including teachers, more readily access legal assistance. The service involves the fortnightly deployment of a practicing lawyer, known as a legal liaison officer, to the colleges. This initiative has been structurally linked to our Youth Law Centre, a long-established focus of Legal Aid ACT. Since September 2020, when the service began, Legal Aid has deployed 3 solicitors on a part-time basis to act as legal liaison officers in the colleges. These officers attend the college campus from 9 a.m. to 4 p.m. on their designated day, offering services to all students aged 16 to 19, their families and college staff. When on site at a college campus, the officers is available to speak with students by appointment, by referral, or on a walk-in basis. The officer is also available to the families of students by appointment. Having access to one of our offices on campus means that people are able to obtain free, confidential legal advice within a familiar and safe environment. Students who have engaged the services are provided with the officer's email address to facilitate ongoing legal assistance outside of the schooling context. If a student contacts an officer outside the school, that officer may attend the school again, provide assistance over the phone, or arrange for an appointment for the student when next on campus. It will depend on the urgency or the immediacy of the issue. Well, what are our legal issues we're seeing, and what are these early statistics? The service provides legal assistance across a wide array of legal issues. The primary areas of inquiry include family and domestic violence, sexual assault and victims of crime, employment law, young people's rights in relation to leaving home, obtaining medical records, etc., and personal protection, bullying and harassment. Not surprising, really. The service commenced on the 1st of September 2020, as I said. Since then, to May 21, the service has provided to a total of 192 individuals with assistance, with over 50% of those involving a family violence indicator. During this period, the officers have also conducted a number of community legal education sessions to ensure students are aware of their legal rights and aid their identification of these issues, and as a way of getting into the classrooms so they can see what kind of services we provide. In fact, in the first 2 months of the services, we provided CLE to over 500 students in 23 sessions. I would like to illustrate the effectiveness of the service through a selection of case studies. The positive relationship between the college staff and the legal liaison officers has been invaluable. Given the rapport with college staff, students will often initially disclose their legal issue to teachers, who are then able to refer them to the legal liaison officer. As such, the presence of these officers within the college context is largely dependent on the willingness of teachers and other staff to embrace and utilise our services. So there are 3 case studies. The first is this. One student who engaged the legal liaison officer on campus was referred to the service after confiding in a teacher that her parents had demanded she return home so they could leave Australia. Whilst off campus, the legal liaison officer was able to provide urgent migration advice with the assistance of our own migration agent here at Legal Aid ACT. A community liaison officer was also involved to provide assistance in safety, planning and connecting the student with vital support services outside the family. The ongoing presence of the legal liaison officer on campus meant that this student had access to legal assistance in the event that her circumstances escalated once more. The second case study. An 18-year-old male presented to the legal liaison officer after being referred to the college's wellbeing team. Given their age, this individual was primarily concerned with the prospect of moving out of home and any legal consequences he should be aware of. During that contact, the legal liaison officer identified family violence indicators, such as emotional, physical and economic abuse, and therefore raised the possibility of applying for a family violence order for their protection. The student appreciated this information, but ultimately determined that moving out of home was his primary objective. Therefore, the legal liaison officer primarily provided non-legal support, for example, writing a letter outlining the client's circumstances for the purposes of a social service application. The student indicated that he would return to the legal liaison officer for further advice once he had received his lease agreement where he was going to then reside. The final case study. With the support of their college youth worker, a student presented to the legal liaison officer prior to appearing in the children's court for a number of criminal charges. The student was distressed, armed with little knowledge as to what legal supports were available. The legal liaison officer gave the student primarily advice in relation to court procedures and arranged duty legal representation from Legal Aid ACT's criminal practice lawyers who would be at court for them. The legal liaison officer also assisted the student in applying for a grant of aid to ensure they received ongoing legal assistance from the criminal legal practice. I think these case studies underline the value of the legal liaison officer's presence on campus and the ongoing support which is being provided to young people. Of course, Legal Aid AC is not the only service being provided like this around Australia, and in particular, New South Wales and Victoria have similar programs. The 2 programs in New South Wales are the Mid-North Coast Community Legal Centre, which deploys a lawyer once monthly to the Macleay Valley Workplace Learning Centre to provide legal assistance and facilitate education sessions. This program places lawyers in the school catering to the needs of young people who are disengaged from the education system. Legal Aid New South Wales also offers a broad-ranging children's legal service, catering specifically to children and young people under the age of 18, navigating the criminal justice system and providing free legal education sessions for schools across the state of New South Wales. As I indicated, Victoria has 2 programs. In 2015, the West Justice launched the School Lawyer Project, placing a solicitor full-time at the Grange College in Melbourne's outer suburbs. Like our service, the on-site lawyer provides service to students and their parents. However, the primary focus of the on-site lawyer is to provide legal advice and actual legal representation to approximately 1,600 students from a diverse range of cultural and socio-economic backgrounds. By offering early intervention and prevention, the program aims to increase students' legal knowledge and subsequently decrease their interaction with the justice system. Anecdotally, evidence has demonstrated that this early intervention in relation to contemporary issues such as sexting has reduced the students' involvement in such behaviour. The lawyer often hears legal issues relating to public transport fines, criminal matters, family violence and tenancy-related matters, and also conducts legal education sessions in the class. Victoria Legal Aid has a similar program, placing a lawyer once a week at a secondary college in Geelong, and that's been piloted since 2016. The on-site lawyer provides assistance to students enrolled in the school, as well as their parents. On-site lawyers have stated that the familiar environment of the student's school ensures that legal assistance is easy to access and reduces any potential stress or anxiety encountered when accessing these services. Matters encountered include family violence, employment issues, and criminal offences. So what can we conclude? The experience of other programs around Australia echoes what is being achieved in the ACT. Although in its early stages of development, Legal Aid ACT's Colleges Legal Liaison Initiative has been very successful in increasing knowledge of the justice system through education sessions and providing immediate access to legal assistance services for young people, their parents, and other relevant people in the context of the schooling environment. In doing so, Legal Aid ACT has been able to mitigate a number of the barriers to justice encountered by young people and empower them to access the justice system in circumstances where they would not normally gain access. The key to our success is immediate availability of lawyers to students at the colleges. And our experience indicates that the service has a growing cohort of clients. Indeed, there are 6,000 students in colleges across the Australian Capital Territory. Currently, it would seem that the impact of the services is only limited by the frequency of lawyer visits and their presence at the colleges. Perhaps the future of the College Legal Liaison Initiative could see an increase in the frequency of our presence in all of these schools, both public and private, extending perhaps to lower levels of the high school and potentially even primary schools. Thank you for the opportunity to address you on this topic. It's an important and successful initiative.
Thank you very much, John. We have been able to learn a lot, but we have Avram who wants to ask a question. Over to you, Avram. Thank you very much.
Hi, it's not a question really, simply to mention a new book which I put in the chat. I think it's a really important one. Professor Michael Freeman of University College, in his emeritus stage, has rethought position of law for children, and this really is a very good tome in helping to rethink the situation across the world for children and reposition it. But thank you very much for all those papers that we've heard this morning. Apologies for coming in simply to mention this item.
Thank you very much, Avram. I will ask a few questions. I don't know if anybody wants to ask. Other than that, I first of all want to say this morning, you have really mentioned quite a number of projects with some successful, some not so successful. And for the ones which are successful, what are the reasons for those projects succeeding?
Well, I think in relation to our program, it's access in the right environment. I found over many, many years that children and young people tend not to get assistance till after they're in trouble, what we do by placing these lawyers inside the schools is give them ready access that is confidential, and that's increased their. It's just because they can come and see us, they do. If they had to come into office, they probably wouldn't come until they were picked up by the police.
Sarah has a question. Can we hear from Sarah, please?
Hi, John. I was just interested whether your lawyers had any specific training to do that legal liaison role, and if so, what that was.
So we've been lucky enough to engage an ex-school teacher, high school teacher, as the lead person. She provides training to our students. There's been an induction program as well in each of the schools, and of course, all of them have strong legal general practice background and have had previous experience working in the family violence area. We tried to get lawyers who weren't too old, who were able to relate to the students. But on the other hand, we needed lawyers with 1, 2, 3 years experience so they could manage the host of issues that have come in.
Thank you very much. I am very happy to hear about the student support for lawyers. I think it's a very good program. I must congratulate you. I only wish we could have the resources to replicate it, but congratulations for the forward-thinking program. But what I want to ask is, what about those people who are young people and are not in schools? Is there something else that they can benefit from, or there is something which could be done for them?
Across Canberra, there are a number of services, including community legal centres, that have specialist programs for homeless people. But also in relation to our services, we provide outreach at a whole range of sites, including shopping centres, sometimes sporting activities, and we try and we'll have a pop-up stall where a particular activity is happening. There might be a range of in particular sporting activities or cultural activities that we attend.
I want to thank you very much, and then to all of you who took part in this session, to say it has been great to hear from all the speakers. And we are very sure that the emerging trends will also replicate and also make of use what you have told us. We want to thank everybody and thank ILAG. Okay, Jane, can we hear you?
Thank you. Actually, my question was asked by Sarah, which was about the training of those lawyers. But John, what I'm hearing from you is that you're recruiting lawyers who have the breadth of experience. I was particularly interested in the fact that they're, having to advise across, quite a wide range of issues. But obviously, that's something you look for in recruitment. And I guess the other question I had was, how far, what level of service do they provide? So obviously, advice service and linking to specialist teams, but do they undertake casework and representation themselves for young people?
Yes, there's actually only one FTE or one position, so we share it between 3 people. So they all have other caseloads, particularly around family violence and civil law in particular. We think that keeps them on their guard. The in-house referral, or the hot referrals to our domestic violence team are made, and also to our community liaison officers for social support. So we utilise the full structure of our services in that way.
Thank you very much. I see another hand up. Yes, Peter, can we hear you? Thank you.
Yes, it's possible. Thank you. Thank all the presentators. And I have questions first for John, and then also for Agnes and John Borthwick, but we'll do it one by one. John, I learned from your paper or presentation that specialization for both judges and lawyers is actually a problem. And read more or less that you think that the special family court will boost the quality of the service. And is it an option in your country that both judges and lawyers work together to formulate quality requirements for this type of work, and also draw up and follow up a training together and make a program together so you can take each other by your hand?
Peter, hi, Peter. I think that question's to me. Yeah, I would certainly see that's not what happens at the moment. And the whole issue of shared training or joint learning events is something that we have very little history of. It is, again, just picking up on recommendations in the likes of the Norgrove Review in England and Wales 9 or 10 years ago. That was one of the key recommendations. And again, similarly in other family law justice reviews, that issue has cropped up. We haven't been good at it to date. I think we've improved very significantly in the last couple of years. And I suppose what I would say is that this separation of powers issue, I think, has been in the past interpreted in a very unhelpful way. And in the past, judges never went near, or the department, government arms of government and the judiciary hardly ever talked to each other about anything. I think that's changed a lot over the last 2 or 3 years. I think we are seeing far more joint learning events. I think COVID-19 has had a really positive impact there. I think we're now seeing judges, practitioners, other stakeholders on Zoom calls together, talking to each other, listening to each other, hearing each other's views. When the whole pandemic started, there were presidents of courts hosting Zoom, of different court jurisdictions, hosting Zoom calls and really hearing what people had to say. And as I say, this just wasn't part of our practice or our norm before the pandemic. But I think that's beginning to lead to the likes of shared training events. I mentioned the scheme, the general scheme of a family court bill. I think that's going to, when that's enacted, that's going to place considerable emphasis on training and education, which I think we don't have at the moment. At the moment, there's no speciality, no training, no expertise required on the part of judges to deal with family law cases. But look, as I say, I think there's a few good things happening. Some of them, in fairness, prompted by COVID-19, and that hopefully will shape things better over the next few years. Thanks, Peter.
Okay, good luck with it, John. And I saw.
I see another hand up. Jean? Yes, can we hear a question from Jean? Jean, can you hear me? Hello, Jean?
Yes, I thought I was unmuted. I've worked in legal aid for a long time, been in the criminal system, and this issue of children and youth. When I read the papers, I saw the norms laid out in some idealistic way, and then I think about the real world of for all the things about this transition from little kids to the middle schoolers and teens, that there is material out there. I've read some of it, but I'm not an expert on the development of the human brain and this transition from adorable first, second, and third graders to middle schoolers, and then to, by the time you get to 8th, 9th, 10th, and into high school, age just isn't a good indicator of the social controls, of the values, of the thinking process, of children who can appear to be adults, but are really still in an 11 or 12-year-old world. And so I love John's program of having resource people available for kids to go to, but likely you're getting, it's a very good thing. You're getting the kids who are already at some kind of crisis moment in their life or problematic moment. And so the issue is, how can we do better at these critical years of transition from childhood to being really responsible adults? It's such a vulnerable time, and we've had horrible events in the United States about this. The Central Park Five jailed 5 kids and accused them of a rape, and they were all innocent, and they couldn't make their case. They were the victims of societal prejudice, but they were in this incredibly vulnerable period of time, particularly for males. And
Shane, we reached
so
our
any
time limit.
outreach
Others
is
will
good, but
join.
there's a
So
lot to do.
Yes. Hello.
So if I could just say one thing, in Australia, we're arguing about the age of minimum criminal responsibility. And if I can say anything in the context of what you've just described, Jean, it is that we need to keep children out of the court system as much as possible.
I agree. I agree. And age isn't always an indicator of adult or child. It's very difficult, very difficult.
All right,
okay, Claire,
thank
I
you.
think you can close the session. I assume the other session will join us shortly. So it's up to you.
Thank you very much to everybody. I'm sure it has been wonderful, a very good interactive session. We have learned something, especially from some of our experts here. And I want to thank everybody. I think we can now go back to the main session. Thank you.
These are important issues, so I was glad there was so much attention for this session and the subject of juveniles and children. So a lot to say about it, and probably a lot of questions. I see that several jurisdictions go and look for other solutions to find the right path. And also I was also looking to John Brosik's presentation when he started saying, I had a record in this area, but mixed successes. So curious to know what are the pitfalls and how can you move on faster, because it's a difficult area. And if you are successful in that, I think you can get a lot of benefit for society in general. So that was, hope that we can do more on this issue.
Peter, early intervention gives us the best chance at helping kids and young people, and it's getting that access to them. They just won't come. My experience is that they won't come till after they've got into trouble.
Yeah,
and so by moving out into their environments where they are comfortable and making ourselves accessible, that seems to me the key to it. I mean, many years ago, when I was teaching law, I ran a clinic on the beach at Newcastle with the aim of, it was very successful. We got a lot of young people along to see the students there, and because we were there in their environment.
Okay. But I was wondering, John, if I may ask the question, moving to the beach is probably better than, why did you move to students? Maybe misunderstanding what students are, but it's the higher educated people. So that was, okay. Did you move to that direction throughout it went, or?
Yeah, Peter, I ran a summer clinic at the university, and it was called Law on the Beach.
Okay.
Many students who wanted to attend.
Yeah, but
I could just imagine it, John. I mean, really, we'd regard that as the soft option.
They did, but it was we actually got clients. So
it's related to the bikes in Denmark and in Belgium, Alan. So you need to go to the people.
That's right.
Where they have.
Yeah. The other session, people are rejoining us. Annika's back, and we've got the numbers are creeping back up. So welcome everybody. Glad you've made it back. Some of you. I attended the second session, which had a very lively presentation from Annika. And then a presentation from Andre Castro, which when I first got it, I thought, I wonder what interest there will be in this. Well, I was quite wrong. There was a lot of interest because what Andre was showing us was that you can use class actions normally thought of as a civil initiative to restrain the police and prosecution in Brazil. And some of you may have heard in the United Kingdom, we've had a huge scandal involving the post office and how they prosecuted a lot of people who ran post offices for alleged theft from the post office, when in fact, all along, it was a very defective piece of software. And they carried on prosecuting and bankrupting and imprisoning a whole swathe of people, hundreds of them. And all along, the problem was the software and the prosecutors. It was a private prosecution, but the lawyers involved appear to not have covered themselves with glory. And one does wonder whether a multi-party action might have been possible. In the end, they did use a representative action, but a multi-party action might have been quite interesting. Anyway, can I just say that we've had a splendid day. The technology papers at the beginning, Roger and Becky got us off to a very innovative and challenging start, which provoked lots of discussion, which could have gone on for a long time. And then we split into 4A and 4B. I didn't see the juvenile sessions, but I will be able to see the papers apart from John's, which I'll see on the recording. And I would say that everybody seems to have entered into the spirit of things. And we got some lively questions at all sessions. So well done, everybody. And for those of you in the Americas, even more well done. Kleber and Becky and all those who are in the middle of the night. Well done, Jean, you're still awake. I can see it too. And there's Kleber, he's looking bright and bushy tail. Kleber, what time in the day is it with you? It must be about 2 in the morning.
It is now 6:30 a.m. The sun, no, it's cloudy, but the day is starting now in Petropolis.
Well, there you go. And I must say there are certain advantages. I don't normally get up at 5:30, but there are certain advantages that here we are. We're going to be finished in Britain, the conference, by 10:30. I've got the rest of the day to prepare for the next conference, the next day of the conference. Well, thank you all to the moderators and the backup moderators, and for all of you who attended. It's been a wonderful day, and I look forward to seeing you all tomorrow.
Okay, bye.
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 Thanks, Alan. Thanks, all.
Bye, everyone.
Bye.
Bye, everybody.
Bye.
Thank you, Annika. Bye, Colin.
Bye.
Bye, everybody.
Bye-bye.